You're watching The Legal Breakdown. Glenn, we have a major update that took me completely by surprise about the Letitia James prosecution. So can you explain what that update is?
Yeah, Brian, when I finally got a hold of the indictment that Trump flunky U.S. Attorney Lindsay Halligan asked the grand jury to vote out against New York State Attorney General Letitia James, I was kind of taken aback. So I looked at the allegations. It's a 2-count indictment alleging that Tish James committed bank fraud and she made false statements to the bank in the process of filling out her loan paperwork. So it's basically one charge multiplied into 2. But what really I found staggering and telling about just how weak this indictment is here is what it alleges. And I'm not taking any of it as true or as fact. I need to see admissible evidence in a court of law before I'm willing to believe anything that insurance lawyer Lindsay Halligan put in this indictment. But here's the allegation. Letitia James was looking to purchase a house in Norfolk, Virginia. She found a fairly modest, they share the address of it in the indictment. People can go online and look at it. A very modest little house that was going for $137,000. She filled out paperwork for a loan of about $109,000 to purchase the house. Now, she secured a loan saying, according to the indictment, that she was going to use this as a secondary residence. And that allowed her to get a beneficial interest rate on the loan. However, she ended up renting it out to a family of 3 at some point. We don't know when, after she purchased it. And if she had purchased a house with a loan that applied to rental property, it would have been a slightly different interest rate. So here is what hardened criminal Letitia James, that marauder, defrauded the bank out of. When you run the numbers, the allegation is that because of the favorable loan terms she got, she actually ended up defrauding the bank out of $52.77 a month over the life of the loan. Crime of the century, here we come. Brian, there is a tried and true statement that I think we're all familiar with. Don't make a federal case out of it. Well, here is the poster child for don't make a federal case out of it. But mind you, even if everything in the indictment is true, and she did all of this knowingly and intentionally rather than after she purchased a house, maybe decided at some point, I'm going to rent the property out for a period of time. That would be a defense, frankly. It would undermine criminal intent. But even if you assume she committed a crime, what it netted her was $52.77 a month, courtesy of a slightly more favorable interest rate. Over the life of a 30-year loan, it would have come to just under $19,000. There is good reason, even if that's all true, that no federal prosecutor in their right mind would bring federal charges based on $52 and change a month.
Glenn, does this even rise to the level of a felony, given that usually small dollar crimes are something that ends up as, misdemeanors or even in civil court? I know this is not really, we're talking apples and oranges here, but for a sum this low, I'm sorry, what are we doing here?
What we're doing here is vindictively prosecuting Letitia James on the heels of a vindictive indictment of James Comey. This is a pattern that is emerging. Lindsay Halligan, insurance lawyer, completely unqualified to obtain indictments or prosecute criminal cases, went in and got these 2 indictments. Now, remember, the career prosecutors who handled these 2 investigations declined to bring charges. In fact, in the Tish James case, the career prosecutor, 18 years at the Department of Justice, Elizabeth Yusi, looked at it and said, we don't even have probable cause to indict anything, never mind prove it beyond a reasonable doubt at trial. So these seem to be blatantly, transparently vindictive prosecutions, and I think they will both likely be dismissed on motions to dismiss based on vindictive prosecution. But no, to answer your question, if you fill out paperwork intentionally falsely and you obtain a bank loan, the feds would ordinarily not take that unless there are big dollar amounts involved, not $52 a month. You know, it might also violate Virginia state law to falsely fill out paperwork. Brian, I'll tell you, even state prosecutorial authorities would look at this, and there is no way, in my experience, they would bring a criminal charge based on $52 a month, even assuming they could prove criminal intent and a knowing and intentional fraudulent entry on a bank record.
Just a quick reminder for those who are watching right now, if you'd like to follow along with this case as it progresses through the legal system, please make sure to subscribe to both of our channels. It's completely free, but a great way to support our work and to support independent media more broadly. So I'm going to put the links to both of our channels in the post description of this video. If you're not yet subscribed, please help us out and subscribe. Glenn, it's worth asking here because you and I have spoken about the prospect of vindictive or selective prosecution before. Does the fact that the amount at play here, $52 a month, does the fact that that is so low lend itself even further to this idea that this is a vindictive prosecution, given the fact that this is not something that would ever have been prosecuted if it wasn't the political opponent of the president?
It does, Brian, and here's why. There are two separate doctrines that are very closely related: vindictive prosecution and selective prosecution. Basically, you're being prosecuted for the wrong reason, for a reason that violates your due process rights and your equal protection of the laws. So a selective prosecution defense would look like, okay, we are going to survey all other bank fraud prosecutions ever brought by the federal government, or perhaps brought in the last 10 or 20 years, and we're going to see if there was ever one that involved, you know, defrauding a bank out of $52 a month under similar circumstances. I think they're going to be hard-pressed to find any comparable case, which will breathe life into their selective prosecution defense and their vindictive prosecution defense. Every single word ever uttered by Donald Trump, you know, criticizing, name-calling, excoriating, attacking Letitia James, every word said or posted by Donald Trump will become admissible evidence on a motion to dismiss for vindictive prosecution. So I feel like Letitia James, you know, may have multiple winning motions to dismiss.
Is there a world where this doesn't even get to that point where a judge can look at this and be like, you know, have the same reaction that you and I did, which is, what are we doing here? And just dismiss this thing before Letitia James or her attorneys even have to say a word?
So the answer is no. In a civil case, that's called a summary judgment. You know, even assuming all of the facts are true as reflected in the charging document, the complaint in a civil lawsuit, a judge can throw it out before there's ever an evidentiary hearing. Not so in a criminal case. There has to be a motions hearing. Sometimes that motions hearing can be by what we call proffer, where the parties just argue, look, judge, there's no there. But ordinarily it goes to an evidentiary hearing. Both sides present evidence. The judge looks at it, evaluates it, applies the law to it, and in a case like this likely decides that Tish James' due process rights against being prosecuted vindictively or selectively have been violated, and the judge can dismiss it, including with prejudice, which means there's no way to clean it up, to rehabilitate it, and to re-indict her on these charges.
But let's take a few steps ahead and think about what happens in the event of an appeal. If a judge dismisses this thing with prejudice, that doesn't preclude the ability of the Trump team here, of these prosecutors, to appeal if they lose, does it?
Yeah, no. Ordinarily, you can't appeal a loss in a criminal case if you're the prosecutor. There are some exceptions. If a judge litigates a motion and that motion is case dispositive and results in a dismissal, then the government, the prosecution, does have some limited appeal rights. So it may very well be that they can appeal claiming that the judge was so far out of bounds factually and or legally in dismissing the case based on the record that was established during the motions hearing that the government should win a reversal on appeal and the charges should be reinstated.
And finally, let's finish off with this. What are next steps in this case? What should we expect, given the fact that we now know that this case is predicated on all of $52 a month not being paid by Letitia James?
Yes, so Tish James is scheduled to be arraigned. That is the first court appearance after somebody has been indicted on, I believe, October 24th. Now, it's going to be in the federal court down in Norfolk, Virginia, which is also part of the Eastern District of Virginia U.S. Attorney's Office. There's a satellite office down in Norfolk, and there's a federal court down in Norfolk. So I may be getting in my car and driving down there to attend that arraignment, just as I was sitting in the Jim Comey arraignment up in Alexandria, Virginia. She'll enter a plea. She'll be put on release on personal recognizance, and she will probably do something akin to what James Comey's defense lawyers do, put on the record all of the motions that they intend to file attacking what has gone on here regarding this apparently vindictive prosecution.
Is there a world where the Trump team tries to have her incarcerated pending this trial?
You know, Brian, with the way Trump runs the executive branch as if it were a criminal organization, never say never. But I'll tell you, there was no question in the Comey arraignment where the judge said basically, I assume you're not asking for any conditions or pretrial detention. And the prosecutor said, that's right, Your Honor. I think we'll see the same thing in the Letitia James arraignment.
Okay, well, the last thing that I'll ask is maybe while you're there in Norfolk, Virginia, if you can get a legal breakdown exclusive with the New York Attorney General for us.
I'll do my best.
All right. Well, for those who are watching, if you'd like to see that and follow along with our coverage as it continues to play out, not just with this case, but the Comey indictment and any other legal news, please make sure to subscribe. The links to both of our channels are right here on the screen. Again, it's a great way to support our work. It's completely free and a great way to show some support for independent media. I'm Brian Tyler Cohen.
And I'm Glenn Kirshner.
You're watching The Legal Breakdown.